The title, Court of Protection, speaks for itself. It protects vulnerable people. There's one for welfare and health decisions, and there's another one for property and financial decisions.
Sometimes family members assume that they know what the person wants or what they should want, and it isn't necessarily aligned with what they do want.
Statutory wills are primarily financial and property matter, but we take into account not only the past wishes of the person, but also the impact of behaviours around them now. Hello, today I'm going to be speaking to Kirsty Buxton, who is a solicitor in our Court of Protection team at Giles Wilson. We're going to be talking about the Court of Protection, the bad press that it's received, and to demystify it. So, hello Kirsty.
Hello.
Thanks for coming and joining me. We could speak for
having us.
hours about the Court of Protection and why we're such fans of it, but just a little intro about what you do, the qualification you've got, and why you love the Court of Protection as much as I do.
Absolutely. So I have the STEP diploma in advising vulnerable clients, and one of the reasons I did that was to try and further my knowledge in respect of Court of Protection matters, as I have a real passion for this work. One of my favourite areas of work actually is working with people who lack capacity and potentially are vulnerable, and that's something that I feel that you can get a real benefit from, to show how your work can impact their lives. So it's a really special area of law.
Completely. It's so special, and the title, Court of Protection, speaks for itself. It protects vulnerable people, but it also empowers those who have been wrongly thought to lack capacity, and the judges have a real ability, don't they, to cut through and work out what's in their best interests.
Absolutely. I think one of the things that really upset me is when someone says, oh, so-and-so's got capacity. And I say, capacity to do what? Because as we know under the Mental Capacity Act, capacity is decision and time specific. So someone can have capacity to decide where to live, but they may not have capacity to manage their finances. So it can be a real spectrum of decisions that need to be taken.
Absolutely. And I think this is a good opportunity to chat about that, about how we can think we know what's best, maybe for our older relative, because we're fearful for their safety. We want to protect them from any risk. But actually, we must remember who they are, what their past wishes were, how they wanted to live their life. And they might be more infirm and need help. But it's for us, when they come to us, and we get clients that come to us like in that position, worried, and we talk them through it. So perhaps, I know you had a client last week we were discussing.
Absolutely. There was actually a very good example of this in terms of a client who was trying to complete a property sale last week, and he was a joint owner with his wife, and his wife subsequently has lost capacity. I visited her and determined that I was unable to complete the property sale, and now we are going to be starting court protection proceedings in order to progress that. So it does really impact on people's day-to-day lives and things that they may believe that they could do beforehand. If you have a subsequent loss of capacity due to an illness or other medical condition that has progressed, then it can really impact. So it's important that people do have advisors there who can help them to continue, for example, with property sale if capacity is lost. But in order to do that, they have to get the right tools and the right authority.
Yeah, and of course, had she made a power of attorney, a lasting power of attorney, specifically to deal with property and affairs, because there are two. There's one for welfare and health decisions, and there's another one for property and financial decisions. And in your case, had the wife appointed an attorney other than her husband, could have progressed with the sale, couldn't you?
Exactly. So we certainly have two branches, which is one is the powers of attorney, which is helpful with people with capacity to be able to put in place their wishes. But the court of protection is going to be the second option when people lack capacity to decide who they wish to appoint, in which case it would be the court's decision based on the evidence as to who's the most suitable person to appoint, be it a family member, a relative, or a professional to help or make decisions that the person's no longer able to make.
Yes, and going back to those headlines that the bad press that the Court of Protection gets. We've seen headlines in certain newspapers about, I wanted to take my mother to Turkey to live with me to keep her safe. And it might go to the court, who then say, actually, mum can decide for herself, or she'd put it in writing before that she didn't want to go abroad. And
absolutely,
it's whoever gets the press first, isn't it?
Exactly. And I think also under the Principles of the Mental Capacity Act, it does say that someone's not to be presumed as lacking capacity purely because they make an unwise decision. And I believe that sometimes family members assume that they know what the person wants or what they should want, and it isn't necessarily aligned with what they do want, or may have said in the past that they want to happen to them, or what decisions need to be made.
And we act for, obviously, sometimes the vulnerable person who's lost capacity, maybe one relative brings them to us, or a social worker or an advocate, or one of the family members, a spouse, even a friend, who's believing that that person's being controlled in a way that they wouldn't have wanted.
Absolutely. We see it more and more prevalent with financial abuse cases. So even if someone does have an attorney, it doesn't necessarily mean that they've appointed the right person. They may have trusted that person, and the person may have broken the trust. And that was evidenced in a case that was brought to us last week as well. And again, those are the type of cases that we do deal with, in trying to manage the risk to the person who's maybe made the power but subsequently lost capacity, and then trying to work out the next steps for them to protect them from any further abuse, and try and put them back in the position they've been in had the person they trusted not abused their position of trust. Yeah,
absolutely. And last resort is, of course, to have a professional appointed rather than a family member. And
absolutely.
we
absolutely.
do that.
I believe most family members do wish to have themselves appointed for a person that lacks capacity, but sometimes it's not appropriate if potentially there is only relatives who are older than the person who has lost capacity. Maybe they don't have any children of their own. Maybe they've not got any relatives that are close to them, or friends who feel able to take on the responsibility of potentially managing someone's finances. There is a lot of work sometimes in cases where people have large assets but maybe don't have children, or they've not utilised their assets in a good way. So sometimes people don't necessarily want to take on those responsibilities. They want to ensure their relative is protected, but they, for their own personal reasons, are unable to. So it is really important to know that there are professionals who can take on that work on behalf of the person's lost capacity, and also to support the family members. I know that the cases where we have, and you are appointed as a deputy for people who've lost capacity, we still maintain a good relationship with the families of the people who we act for, to ensure that there's no there's complete transparency, and that they know that we're protecting the person who's lost capacity and their position.
Yeah. I'd like to take a moment to discuss statutory wills, because most people that I chat to about those find those quite fascinating, and I think they are. So just quickly, they are, of course, the wills made for people who lack the mental capacity to change their own will. And that might sound bizarre, that you can go and make a will for somebody who doesn't understand how to make a will. But sometimes the court do grant statutory wills if there's good reason for doing so.
Absolutely.
Example, somebody has left their house to somebody and their cash to somebody else. The house being the larger asset, but then the house has to be sold for care home fees, and all of a sudden that person that was going to get the larger asset is going to get nothing, and the cash person's going to get double.
Yep, absolutely. And also there is merits of having an executor appointed if there is going to be family squabbles. It's not clear who's necessarily going to administer the estate, so sometimes it's helpful to have someone appointed as an executor. I think some people are not aware of a statutory will, and sometimes they say, oh, well, if they die, then it's going to be the intestacy rules, but they definitely didn't want this person to inherit. They've not had anything to do with this relative. And we know under the intestacy rules, which is set by statute, who inherits in the event someone dies without a will, they might not want those people to inherit, and they might have been clear about that, but they've lost capacity to make a will. So they're not able to give those instructions as to what they want. sometimes it's still possible to take people's wishes and feelings as to who they want to inherit, and that can form the basis of a statutory will. So there is possible to rectify errors in previous wills, or in one example, there was a person that died, the person that made a will, leaving it to their 2 children, but one of the children died and it was not clear what should happen to that share. And we did an application to set out the fact that that share should go to her children, because they may not have otherwise inherited under the law. So it's helpful to know that it's not just a case of making a will for someone who doesn't have a will. It might be a case of making a will to demystify some of the issues that could arise on death as well.
Yeah, and to rectify a change that's happened since they last made a will.
Absolutely.
And I know that people are sometimes nervous about the cost of all of this, but provided the action being taken is a reasonable one, and you get advice as to this, as to whether you've got a good case or not, the costs are usually paid for from the person's own estate, aren't they?
Absolutely, and especially with statutory will cases, there has to be that analysis of whether it's in the person's best interest to use their money for this. So it's not a case that someone can just go to court and make a will for you that has no substance, is completely removed from your own wishes and feelings. There are structures in place through the court, through the appointment of the official solicitor, who would act as litigation friends. That's a representative for someone who lacks capacity so that they are legally represented, who would review the evidence, provide an opinion independently of the other parties, to present to the court. So it's not a straightforward application for a statutory will, but there is enough checks and balances to show that it's got to be a reasonable need for that person, and it's in their best interest to make one. So it's not just a case of someone who wants all your money going to the court and
absolutely
making a will that way.
I mean, I recently did one that was interesting, where somebody hadn't made a will, kept saying they were going to get around to it, then had an incident where they lost capacity, but was making regular donations to a charity, for example. And so it was pretty clear that they would probably want to benefit charity in their will, but not entirely. But as their estate was going to be subject to inheritance tax, we did that clever thing where if you leave a certain percentage, more than 10%, to charity in a will, then you get a reduction on the rate of inheritance tax. And that was a really well-received statutory will that went through almost by negotiation. The court always does have to approve it, but the costs are reduced significantly by people getting around a table and trying to agree what would be the best decision.
Collaborative approach is always preferred, and I think if everyone's in agreement, then that also keeps costs down as well. It's always better if you are thinking of doing a statutory will to see what the people who would otherwise benefit, what their position would be and whether they would agree it, because sometimes they would, in which case everyone's in agreement and it's just a case of ensuring that the court also believes it's in best interest. So it is important to establish from the get-go how the case is going to go.
And best interest runs through the whole court of protection, doesn't it?
Absolutely.
And statutory wills are primarily financial and property matter, but we take into account not only the past wishes of the person, but also the impact of behaviours around them now, even though the court divides health and welfare from property and affairs. And I was just going to chat a little bit about health and welfare decisions, which are completely different, aren't they, than property and affairs?
Yes, they are. And I think a lot of people who want to do an application for a deputyship where it affects welfare decisions are parents of children with disabilities or special needs. And there is always that difficulty when the child transitions from being a child legally to an adult. And we see that a lot when parents come to us and they have been told by medical professionals or other areas of support that they're no longer able to make decisions for their child. Now the child is legally an adult. And so welfare applications can be very important at that time, sometimes to make a one-off decision, so a specific decision that needs to be made, for example, where someone should live, or what care and treatment they're to receive if it's an urgent operation. The court's more willing to grant a one-off decision as to who can make decisions of that nature, rather than a full welfare order for deputyship, because the court is of the mind that the person still has the autonomy to make decisions where able. So that they should still have the opportunity to make decisions for themselves. And I think sometimes parents can struggle with that loss of control. And in some areas, you can still have that collaborative decision through what's known as a best interests decision, which can be made by family members, people doing the care for that person, potentially schooling or further educational support. But ultimately, if it's ongoing decisions, then a welfare deputyship order may be more appropriate. So it really is very much case specific and also decision specific. And I think that it's really important that people with disabled children realise that there is an opportunity for them to still advocate for their children, even when they're adults. But if they run into difficulty, that's where the court can help.
Yeah.
Grant them the authority.
And of course, many young people who turning 18 have enough capacity to choose their parents to be their attorneys,
Absolutely.
for example, understanding that they themselves may never have the ability to manage their own finances. So you do a lot of that work, I know, with charities such as MenCap, Scope, etc.
Yes, absolutely. And we also work with advocates as well to try and ensure that people who are maybe perhaps borderline capacity may have some capacity to decide some aspects of their lives, but maybe not fully comprehend more specific or the legal terms or more difficult concepts to grasp. And I think that it's really important that they are adequately supported. So we do try and reach out to various different services, charities, the local authority, safeguarding team, all different types of official bodies to try and really support our clients to make decisions for themselves, because ultimately we want them to succeed and we want them to have a good quality of life. But it is also helpful to know that the court protection is there if there is a decision that they can't take themselves and they're unable to weigh up various issues, perhaps communicate what they want to happen, but they know that there is the court that's there in the background if they need a decision that needs to be made, but they're unable to do so themselves.
I could listen to your calm voice all day long, and I know, having seen you with your clients, that when people have ageing parents who perhaps have got dementia or someone very close to them has had a sudden stroke maybe and lost capacity, and the parents that we were discussing who are very anxious because the child that they've looked after at home has become 18 and suddenly they no longer have the automatic control over them. And providing a calm level of advice that's unemotional, really. And we often say to families, you've got the emotional side and the practical side to deal with. And we're here basically to do the paperwork and to give the advice and to navigate the authorities, advise people of their rights and their obligations. And the courts have great oversight, don't they, through the Office of the Public Guardian too. And there are helplines as well.
That's right. I think that it's really important that people are aware of the fact that they can go to these official bodies if they're concerned, if they suspect financial abuse, if they are worried that someone's not acting correctly, that there are avenues to go through first. One of the advice I always say is, well, have you tried to do anything about this? Have you spoken to local authority, safeguarding team? Have you reported to the Office of the Public Guardian? And I believe that people don't always think that way because sometimes they're clouded in emotions. Sometimes they're just so concerned, they just want things to get done straight away. But there is a process to be done. And I think that it's important that people are signposted to the right places to go for support. It's not just a case that people are on their own. There are agencies out there that can support them. And I think that also with medical services as well, if someone's really concerned about medication people are on, they do have the right to go back to a doctor that prescribed it and really try and discuss and get to the bottom of what the issues are with them first as well.
So one scenario we have quite often is a family with maybe 3 or 4 siblings and the parent needs care, and one child emerges as the main carer. And then quite often, particularly if they've given up work, they might feel they're entitled to be paid out of mother, father's funds, but mother or father can't agree. And they will often say, but they always said I could get paid. But of course, they can't say that now. And would they say that in the context of knowing what money they've got left? So again, there is a specific application, isn't there, that's made to the court for that?
So there's specific application for family gratuitous payments, family care payments, and that's the type of payment that can be made from the person in respect of their caring obligations. It's not the same rate as a normal carer, but it's a reduction to take into consideration the fact that they are a family member doing the caring. I think that the court forms themselves can be quite daunting, and that's where we are there to help try and ensure that everything's very clear, explained, and that people feel really comfortable with the advice that we've given, and the forms are completed to the best standard.
They put the best case forward, but
Absolutely.
essentially, people will always speak to an explanation as to why they're using the parents' money for certain things, but basically you can't help yourself without authority.
No. And that's another thing that we see a lot of, is mixing of funds for people. So people saying, I've put it in a joint account so that I have access. But actually that money shouldn't be in a joint account because it's not held jointly. It should be in an account that's held by that person with their representative as an attorney or a deputy on there. So they have access, but the money belongs purely to the person who's either made the power of attorney or the deputyship order. So it's very important that funds are kept separate to ensure that there is no benefiting from their position.
So I'm being told I've got to wrap this up. So going back to where we started and the bad press about the Court of Protection, hopefully we've done enough to show and illustrate why we're fans of it. But if you want to look after a vulnerable person to the best of your ability in the way that they would want you to, and be honest about it all, the court's on your side, would you say? Absolutely.
The court is there to protect the vulnerable, and I believe that it really does that. It might take a little time, but decisions get made by an independent person, free of emotion, purely on the evidence provided.
Thank you, Kirsty. It's been great speaking to you. Thanks
Thank
ever so
you.
much for your time.